Hi, good morning. I hope audio and video is. Hi, good morning to all of you. I hope audio and video is good for you. We are facing a little bit of internet connectivity these days, so I'm sure this webinar we will have smooth running for a few minutes. My name is Jatin Popat. Welcome you all to this webinar. Uh, Today being a lazy Sunday, thank you for participating. We have so many number of people around attending this webinar. So, welcome to all of you. Uh, we want to take few minutes from you regarding explaining the importance of will, as well as few myth busters and how the process works for writing a will online. Let me take you through a small video which will help you to at least understand what we are going to cover today. It's a 2 minutes quick video. Let me take you through that. Some of the participants are still joining. They're sending a request, so we are waiting for a couple of minutes. Let me explain to you about WillJini. WillJini is a company which is into full succession services. We are serving Indians for past 5 years. We launched in 2014, and as per the request and guidance received from lot many financial institutions which are leading in India, we have developed a software where one can make a will sitting at home at very low cost and without going out or without meeting any legal professional at their own confidentiality. So this is something which we have developed, and we are proud for being a pioneer in India. uh, so will writing is we understand that world over in all the developed country, online will writing is a way of life. People are making an online will in US, UK, Canada, Australia, Singapore for more than 10, 15 years now. And for them, it's like any insurance policy or a mediclaim or a tax filing. They do it very regularly at all the age. They don't wait for quite old age. So this is something we are really taken as one of the clue for Indians. And we have developed this software where people sitting at home can make a will very easy way. And so in past we have seen that people used to have to visit a lawyer or a legal professionals for guidance and making a will, where they have to give time for visit. It may take a few weeks around. So this is something which we are trying to do, that people can do easily without going around, and also the cost, because sometimes the cost of the legal fees, which most of the individuals they feel that how the legal professionals will fee them, charge them. So it's not fixed fees many a times, and so we have tried to reduce the cost here and also the process. Luckily, we have the partners around which are recommending our will to Indians for the customers: HDFC Security, ICICI Security, HDFC Bank, AU Bank, CDSL, Corporation Bank, CDSL. All these are our partners. So you can see around on the screen. These are our partners. So with the help of this financial institution, we are trying to create a lot of awareness and offering this will writing sitting at home. And we are sure that it's the importance is going to be explained to you during this webinar, and you all will be sure that yeah, this is something which one has to start thinking on and start creating a will. So let me take you through some of the features. And before we start, I just want to take you through a very small video which we have prepared, which is just take you 2 minutes. Let me take you to the video. thank you so much for being with us, and thank you for being here for attending this seminar. My wishes to all of you to be safe during this coronavirus issue around. So now let me take you through our today's presentation. This presentation we will take you through is about 30-40 minutes, and where we will take your questions. There are some good announcements for all our participants today for some discounts offer. So let us go through our presentation, and then we'll take you your answers also. So as I mentioned, we are trying to discuss today about the importance of will, the mythbusters, and how you can make a will sitting at home. So we have seen what is our success and planning. We have seen that people around, we all of us have done education, we have done our career, we have created a wealth, we have multiplied our wealth, and so we have now next question coming up is what is next is a success and planning. So we are saying that success and planning has to be done, and has to be done only when you have a good your good sense. It's not that you do it at the last end when you lose your senses. So succession is something, writing a will or creation of family trust. These are the few things that we should do. And we have seen that people are a little slow in India. And we have seen that many people around the world are doing it as a regular exercise, like a medical policy or an insurance policy, which they did almost at the age of 30, 35. So we are for easy and cost-effective solutions, in addition to their legal advisors, which is law firms and the other will advisors. So those are already a traditional way, and also online. So what is a will? We have a question coming up regularly. What is a will? How it is to be made and all. So let me tell you, will is a document in writing, okay, which is could be on a plain paper, because in India writing a will on plain paper is allowed. There is no stamp paper required or something, right? So it's a plain paper written document by you about your assets, and first of all you have to mention about yourself and your family, the details, and your assets, which are the asset you are owning, and which you're in your name. Sometimes it's a joint name. So those are the people who can make a joint will, and your distribution wishes. So your bequest has to be mentioned very clearly that whom you want to give. This is the planning, right? And this can be done, change also in many number of times. You can change every day. You can change every year. You can change every 3 years, 5 years. So these are something which we feel that will is not going to be a only one time exercise, though it is mentioned it's a last will. But yeah, that is something which we must to understand, that will is a document which is in writing about yourself, your asset, and your distribution wishes. And this can be go as a document which help your family to know your wishes in writing, and also to the government and all the agencies what was your wishes. By saying something to the family in a vague manner is not will in India. A will has to be written and signed by you and two witnesses. That's a very basic thing that you please note. There is no stamp paper required. There is no registration mandatory. All these things are not there. Okay. So let me take you through the few of the mythbusters. So there are a few myths around in typically we are seeing in India, where people are always argue, and they try to avoid. So there is an inertia issue. People always keep it at the last resort. In fact, today's our seminar webinar is on writing a will at your home. The very purpose is, last few days we are getting so many calls and inquiries during this lockdown, that people have got time now to go into these details of collecting and making a will. Not because it's a COVID, but because they have got a time to spend around for something which they have kept it on hold. So yeah, this particular period of lockdown, people are doing lot many activities. One of the activities they have chose is writing a will. So it's good that at least something somebody is trying to initiate. We have seen people from 2014-15, they are coming back and writing a will. So it's good for all of them. So let me take you to the first myth. There are people who believe that will has to be written. Typically, you have seen in Hindi movie, it is on the deathbed. Somebody, a lawyer, will come and make a will. Those type of myths they are kept in mind. They feel no, I don't have enough right now. I have not thought over so many arguments they have got, so many inertia issue. So they say that it's going to be late someday in my old age. My question to all of them, what is the old age and why you are saying that you are going to survive to that old age? Do we know our date of expiry? Nobody knows here, right? So we always do planning in advance, whether it's a insurance policy, whether it's a medical claim, whether it's a tax, we do it today. Not we say I will do later, because we don't know date of expiry, right? So why not we think also in this situation that it's not to be done in only old age. We are seeing today people in India are making will at 35 also, like developed countries. So it's not going to be only at the old age. The issue also around that whenever you think that I will make it at old age or retired or something like that, there is a chances because a will has to be written when you are in senses, when there is no medication going around for your mental stability. Some people have some Alzheimer issues, some people go under depression, some people are not well, keeping well themselves. So during those days, writing a will is not legally acceptable by the legal authorities. So please be noted that will has to be written when you are in good senses, you are confident, you know your distribution thought very clearly. Okay. Second myth, which we have seen that lot many people say that I have done all my nominations properly, all my properties are joint name, so why should I think over a will? So people have all arguments just to avoid a will. Let me tell you, nomination is just a trustee arrangement. The government of India has introduced nomination for all the assets, like you have a flat, you have got a demat account, you have got a bank account, locker, everywhere. Nomination is there, we agree, and nomination is allowed to all the owners so that their kin can collect the asset. So the nomination, by way of nomination, your kin, your close relative will collect the assets. They can't say owner. They can't be a legal heir by saying that my name is nominee, so I will be owning the asset. Sorry, he or she is just a trustee to manage your wealth asset till the legal heirs is decided and the legal heir gets their money. Either if you made a will, by way of will, those money will be distributed to those nominees, your legal heirs. The nominee has to do all that thing. And if there is a joint asset, then there will be also equal position for the ownership right. Like if some asset are owned jointly by two people, it will be said 50-50 if there is the ratio is not mentioned anywhere. If there are three people, then the ownership ratio is 33-33-33, right? Please note that whenever there is no will situation, everybody on the family wants to know whom to give what. And for that, the government of India will guide you as per the Hindu Succession Act or whatever succession act is being followed by you as your personal law, right? So Hindu succession law says that any male person, if dies, the legal heirs are mother if she is living, spouse, that is wife, and all the children, married daughter also. So all the people are called the family or legal heirs, and they will be given the asset equally if there is no will. So if there is no will, the family has to go for succession certificate to define who are the lawyers, who are the legal heirs, and what distribution they have to make. So Prashant Nagar is here having a question. Do we have to give full details of asset while making a will? What about assets made after making a will? Do we need to change the will to add a new asset? What if I forgot an asset while making? Good. So, these particular things are a couple of things which we should tell, that we offer two type of will. One is a will where people don't want to give details of asset. They just say, I've got a flat, I've got a jewelry, I've got a insurance policy. So they just give a name. They don't say where it is, what is the value and all. It's fine. So even those assets where we, without giving asset detail, you can make a legal will. That's perfectly fine. You can say that I have got a flat and the detail is known to my family. I got a jewelry detail of are known to my family. So these are fine. Legally it is allowed. Also, whenever you have missed some asset in your will, you can write a residual asset clause where you can sorry. So legal assets, if you're remaining not yeah. So there are some calls coming up. Sorry. So people who have not mentioned few asset or they forgot, or sometimes they've got a digital will, sometimes they've got artifacts, sometimes they've got a painting, some pets, all the things they sometimes they forget in mentioning in the will. So we call it a residual asset clause, where we are saying anything which we have forgot to mention here, this will has to be covered as a part of my will. So the residual clause, any asset which is bought in future, which you are not covered in today's will, there is a future asset clause which always mentioned, so that it's covered in your legal will, which was made earlier also. So those things are always kept in mind when we write a will. Any of your missed asset or future asset we cover. So we state that for nomination and joint ownership, if you have not made a will, there is a possibility that your family might have to go to court of law to decide who will get what, and that will cost and that will be a time consuming. So writing a will in a few minutes with a few costs, it's better than putting your family to hassle and heavy cost. There is a myth also around that if I don't write a will, like in old days, my all the asset my spouse will take, and he or she will decide whom to give what. Yes, this was the situation in past. Even the law was there, India being a very traditional and conventional country, all our relationships, emotions was around our parents' wishes. We never used to ask what is the legality, and that's the situation earlier, where the relations were very strong, bonding were there. We are not saying today relations and bonding are not there, but yeah, we have experience here right now that relations and bonding are taking a back seat against the money and value, the wealth. So people are easily getting debonded if there is no will situation. And even though parents have some wishes, even though wills are not made, they if they say that let us give this to that, they say no. We want to go legally. We want our share, equal share. We don't want to listen to you. And that's how there are issues coming up. And there are so many cases being filed in India. Maximum cases today in India are relating to the will and succession matters. By why? Because the will was not made. There are so many stories going around, right? So the spouse here is not going to take all. It's the wealth has to be distributed as per the will wishes. Whether if you're given to all to spouse, it's fine. If you're given to spouse some percentage, to your kids some percentage, your mother some percentage, it's fine. To your friends, you can write anything. If you're not mentioned, then your close family in the equal ratio will get. But you've written a will, everything will be followed by your family and the government. It is a law. So if you write a will, everything will happen as per your wishes. If not, then it will be happen as per the legality. There's a myth around that yeah, writing a will is really hassle. You have to visit a law firm, you have to go to a legal professional, you have to use stamp paper, you have to do a court, you have to visit court, you have to do notary, you have to do registration. So many myths are around. I want to be very clear here that government of India doesn't need a single penny from you from your will exercise. If you write a will, there is no stamp paper required. You can make a will on plain paper. Please note, you can write a will on plain paper. One. Two, the registration of a will is not mandatory. Few people, they do registration as aiding government as a witness. So you already have two witnesses in your will who will sign in front of you. And if you want to add another witness, which is government of India,
you go and do registration. Some of the people, they feel that family member around could fight and there could be somebody who will challenge and all these things. So they, as a safety precaution, they register a will. We are not saying that registration of will, there won't be any challenge. It is not. Registration will add one more witness to your will, which is Government of India. So registration has to not be mandatory. After writing a will, signing a will, you can do registration during your lifetime. It's not mandatory. You do it tomorrow in 4 months' time like other documents. So registration is not mandatory. You don't have to go to any court of law. Notary public, again, if you want to do one more the witness adding to your will, a notary can help. Once you do notary, you can't do registration. So you have to decide whether you want to go for another third witness in your will. You can decide, and if you want a notary public, you can invite them or you go visit them. They will sign in front of you. So these are the additional things. So the purpose of Ms. Bursar is, this is very simple exercise. A will can be made on a plain paper. It's your wishes. Only care to be taken that it should be a simple and not contradictory in your language. We have seen some people write something in one clause and something others, which contradicts, and that is more likely to challenge from the family because they don't understand it fully what your wishes were. So sometimes those issues you can take care. And these days now we have seen that online will is picking up everywhere in world. Even India, we have seen that people are using online will because it's hassle-free. Everything is confidential. You don't have to discuss anything about your wishes to even your legal professional or anybody who will note down and then they will discuss and send you. So online will writing is a hassle-free. It's very fast. Within 30-40 minutes, you can make your will. You take a printout and sign in front of two witnesses. Will is done. It's very cost-effective also, and it is quite legal. So it's made as per the Indian law. So online will is a way of life. And sitting at home, you are making a will, which is not new. It has been done in world over, and today also it's been done in India, quite a few numbers. So what is online will? It's a will that you are doing yourself. You don't need anybody's help. If you are doing for your parents or some relatives, you can do that on their guidance. It doesn't require calling somebody or meeting somebody or emailing somebody. You just have to go online like any ticket booking or like any other banking facility that you go online. You do login password. You mention details and you get an online will draft will document. You take a printout and you sign. It saves cost. It saves time, and it can be made as per your time zone, and it's quite secure and confidential. So we also offer such online will facility. Our server is completely secure like any other banking institution, and it's really confidential. Nobody can read your will because it's all your whatever you mention is get encrypted in our server. It's really secure and confidential. How secure it is? Yeah, WillJini is promoted by, we are few senior legal professionals. We have a very back and strong IT team. We have got server which is Microsoft Azure server. The website is secure like a bank website. It has been created by industry experts and even the top lawyers have gone through this will draft. So it's all coming as a legal language and properly done. And we have also ensuring a data safety of your will related to information. So it's really secure. We have been, WillJini, as I said, we have been a pioneer in India for last 5-6 years, and we have been covered by many media around in India on print media, on other medias also. So let me take you through a very brief process about how will writing is being done online. It's I've shown the video to you where the process was explained in brief. Now I will just take you through on WillJini server or WillJini website. You can go, you can just read things around because we have got their FAQ book which is in 12 languages. It's free of cost. you can go and download what is will, what about all this question answer that we have in common. Those FAQ books are free of cost. Excuse me. Sorry. Yeah, so you can learn many things on our website. It is free of cost. There are presentations are there. There are videos are there. You can see and learn what is will further after the webinar. On our website, when you want to do a will, just register as a normal registration. Decide your login and password, and then you can select the product. We have got two online products, Express Will and Standard Will, out of which Express Will is cost 1,500 rupees and Standard Will at 4,000. Express Will, where you don't need to give details of the asset, it can be made in 10-15 minutes, and Standard Will can be made with more details and takes about half an hour time. And then you can write your details like yourself, your family, your asset detail. You can mention your distribution wishes, mention your witnesses who is going to sign along with you, and then you say, I have completed. You can preview the will, you can read your will in Word document in legal language, and then you are satisfied. Just take a print, go to generate button. You will be getting a Word document as a will, as your will, and you can take a print out and sign in presence of two witnesses. Two witnesses must. Okay. So let me take you through our basic website slides. So this is the first slide that you normally will get if you create a will online through WillJini, like creating your own profile, a male, female, what is your religion, are you married, unmarried, what are the assets you are owning. So we have symbols around. You have to just go on clicking applicable thing to you. Accordingly, our software will catch and they will ask you the questions. So this is creating your own profile in a very brief way and very quick way. So you have to enter your detail of family, asset, and distribution of wishes. This is the next stage after you create your profile. And these are very simple slides, just like creating a form filling type of thing. You go on entering details, okay? Like this is something which you have shown your immobile property. Where is your flat? So in our standard will, these details are asked to you. If you don't want to answer, you can select I don't want to answer. There is a facility given. For Express Will, we don't ask these details. We just have collected your information that yes, you have got flat and you don't want to give details. So this is something which you can write if you want to wish to write in a standard will. So where is your flat? What is the number? There is no value is asked in all the process. We don't ask any value of the asset. Then there is also a bequest. So you can select bequest slide which will come automatically. They'll ask you whom you want to give your assets. There are two ways you can do, in percentage wise or asset wise. So if you say I want to give it in percentage wise, like 50% to my wife, 25% to my son, 25% to my daughter, these are called a percentage wise. And then there is the asset wise. You have got list on those assets, flat, bank account, demat account, insurance policy. You can decide which asset you want to give it to whom. So any of the option you select, and accordingly you can mention your bequest here so that it is captured in our Word document correctly. So this is something you can take the number 4 as one of the last step is when you take a printout, just read it. It's a Word document. So in anything, if you miss something and you want to add, you can make a correction in the will in a Word document. If you need any of our help, we are always available during the whole process. Whenever you need any support, any help, any guidance from our team, we are there available online chat. We are available on WhatsApp. We are available on email. So, or you call. Anywhere you feel that you need any question about legality or about the software, you can call us. We will help you out. So once you have a will, so once we have a will, Then the will document, you can take a print on Word, any A4 size document, and please invite your witness. The date what we have mentioned on the will, you can correct it also wherever you want. And then on the day when you are signing a will, your two witnesses be there, sign in front of them. If witness want to read it, it's not mandatory. You can say just sign as being you are signing in front of me, and the witness we suggest should be younger to your age, so that those are people are available when you are not there and somebody challenge. Witness is no much role. They have just witnessing that they have signed in front of you, and in case anybody challenge, they will come in the court of law and just say yes, this will was signed by so and so person in my presence. So his role is very limited. Somebody has asked a question. Dharmendra is asking that what is a living will? So living will is something which was earlier not allowed in India, which is now being illegal. So living will is something where people are deciding today that in case if I go on a life support system, if I am under coma, if I am under a situation where I cannot decide myself, in those situations, I don't want to go on a life support system, and the doctor should not drag my death to just unlimited period. So those are the living will has to be done in presence of magistrate. The magistrate will take it, and whenever those situations arise, the magistrate will ask their panel doctor. They will visit the hospital to check, and they can decide to take out the life support, and whatever your wish on your death, they will implement it that also. So even your death, you can decide if you goes on life support system. Earlier, people used to give power of attorneys for family when they are such situations. So power of attorney is always there, that if before your death, anything happens of such medical situation, your family can run your asset and those through a power of attorney. So that was there earlier. Now additional thing is a living will. So far people are not yet very much aware about this living will. Some people in Western countries, they were doing it, and India has now recognized its thing. So we are saying why will today? It's because we are saying that we all are not immortal. Everyone has a date of expiry. People used to take life insurance policy when they are 30. They take a medical claim when they are 30, 35 with the family, when they got married and all. And so those are situation is connected to some uncertainty. A term life insurance policy is connected to your death, where your family will get some wealth, some money. But whom to give what, nobody knows. So we are saying if you are connecting your death situation when you are 30 by taking a life insurance policy, why are you deferring your writing a will? It's just a piece of paper of your wishes. How your wealth to be distributed? It's so simple. Why we want to connect it with something death? You already have connected your life and death when you take on a life insurance policy, right? Okay. So we don't have date of expiry. It can be made anytime. It can be today also, and it's your wealth. And if you don't decide, then who will decide? So it's your wealth. You should take decisions, and so your wishes has to be written. Otherwise, court of law will decide. Okay, or the succession law. So let's not do that. Without your will, your family might have to have hassle in understanding what was your wishes. There may be misunderstanding. There may be invitation of a law firm to your family. There may be a fight. There could be debonding. They may have to go to the court of law to bring a succession certificate. It's very costly and time consuming. So all the hassle can be avoided by just writing a simple will, which can be done in a few minutes. Okay. Now, succession certificate, what we have seen, the court fees are in Mumbai, Maharashtra is 75,000 today, which is likely to go 3 lakhs. So if you avoid writing a will, all the costs and those stuff will come in your family's life. One is hassle. Secondly, delay of the distribution of assets. Thirdly, the cost and the hassle to go to the court of law. So this is something which is really want to take you, that you can make a will at the earliest. We are offering some announcement today for all our participants for being with us, and so that you, and that's some 30 days limited period offer for you. Let me give you this coupon code. So when you want to make a will at WillJini, we are offering 20% discount to you. Being today you are participating in a webinar. Its validity of this special offer is 30 days. Within 30 days, whenever you want to make a will, if you use this coupon code WILL 2020, if you use this coupon code, you will get 20% off during this 1 month period. So wish you all the best. Let me now take you through a few question answers. So a lot of people are asking about joint will. So let me talk about that topic. So far we have seen in India it's really culture and it's a way of life we do, that whenever we own asset, we try to keep a spouse, whether it's husband or wife, we make assets a joint name, whether it's a bank account, locker, demat account, flat, we try to make it joint. Even though even one person has contributed fully, other person as a convenience sake is keep it. So those are the joint assets. But if you please understand legally, once you add somebody in joint, almost you have gifted him that portion. So if you gifted joint your spouse in your flat, more or less you have gifted 50% if there is no clarity. So please understand, legally joint owners are equal owners, because whenever you have to sell or liquidate or withdraw, you need their sign. So they are owners. So joint will is something which we are doing as a customized. We make a husband and wife joint will where husband says, if I die, all assets to be given to wife. Wife says, if I die, give my all assets to husband. And after we both die, it says to be given in this person. We call it a joint will. It's a two people will. The people were also asking today, future property and residual. I already covered it. In a will, we normally cover those clauses. In the clauses where we are saying any residual or any asset which I have not mentioned in my above will, please understand that it is covered. So those things without mentioning are covered legally. And future assets, there is also clause that any future asset from today onwards should also be bequeathed in this fashion. So even the names are not known today and you do any change in your asset base, it is covered legally. Our humble suggestion and recommendation that people should review their will every 2 to 3 years. If there is a major changes, why don't you make a fresh will? Why you want to keep things confusing in minds of your family? So people should make will every 3 to 5 years. You are doing your medical and other policy system, insurance policy every year. So this is one type of renewal. So somebody is asking what is the individual will, what is joint will. I've explained a person who is writing self for self. It is the individual will, and joint will is normally by husband and wife. It can be also by brothers. So there is no law on that. Joint will has to be of two people together. So that is something which you can note, and if you wish, you can do that also. So, as I've explained, if you don't make a will, there could be a lot of hassle. If you have a will, you are just spending some 30, 40 minutes, you are spending a couple of thousand like one family dinner, and you are making a will so that you have already mentioned your wishes to your family, and they know. And it's a legal, acceptable to all court of law. So, will made on a plain paper, signed by you, and two witnesses have signed. It is legal, it is accepted up to Supreme Court. So if you don't make, okay. So if you don't make, you don't want to make, let your family decide, fine. Your family, if you are good, bonded, and they have understanding, maturity, they will not fight. But it could happen that they are misunderstood the whole emotions of yours, or and you have said something to them in past. There could be a misunderstanding. They will fight amongst them. They may go to the court of law for fight. You have seen many cases around, right, in media. It could be celebrity, it could be politician, it could be industrial houses. People are fighting in the court of law, and thousands of crores of wealth is stuck because they are fighting. There nobody yet got distribution. It takes time. Rakesh, what is the role of the partners like HDFC, ICICI, and Muthoot? Rakesh has asked this question. What is the role of the financial institutions as our referral partners? So these are the institutions who have seen our product and our technology and our legal drafts and all, and they are recommending now to their customers to make a will. So as you know that very few people making a will, so they are trying to create awareness through us, and we have tie-up and partnership where our products are being offered to their customers. So they are actually a referral arrangement, partnership arrangement with them. So yeah, people are saying that they question that is it necessary to mention complete detail of the asset, or you can just say general remarks. Both are fine. So far as you are clear, your family is knowing those details. Many a time happens that you have got so many insurance policies, so many wealth assets here and there. Your family will have to struggle to contact and get those details of your demat account, your insurance policy, your those assets, and then they will able to claim. So to cut it little short and more good for them, please write maximum detail you can give. So that is our recommendation. However, if you don't want to write, it's fine. Whatever your family is aware, if you have kept some notebook in the house that these are my assets, and you make a general statement in your will, it is legally acceptable. So Bridges has asked a question: how do you cover HUF in a personal will? Yeah. So HUF, whatever is your share in HUF, you can bequeath. That is legally allowed under the laws, and so you can cover up those assets also in your will. So in a will situation, what we normally suggest, you have to appoint a guardian if somebody is minor. If somebody is minor, please appoint a guardian so that your beneficiary, like you have son and daughter, or somebody who is less than 18 year of age, and you want to appoint a guardian in case something happens to you and your kids are still minor or your grandchildren are minor. So you can appoint a guardian. So that is not mandatory. You can do it if you wish. Secondly, executorship. So people who are executor is also which are going to distribute your asset to the beneficiaries. So executor is anyone from your family who or a beneficiary who will be appointed by you are appointing in a will that this person is going to play a role of executor, and they will distribute the asset to all my beneficiaries as per my will. So it's an authority given. The executor become a legal authority to distribute your assets, which is executorship, and it's not mandatory. You may avoid if you want to, but it is recommended to avoid any misunderstanding. Thirdly, beneficiaries. People are appointing beneficiary. What if a beneficiary dies before me? Husband has wife has made will, or father has made will for son, their grandchildren. Anyone of the beneficiary who have died before the main will maker, then what happens? What about their share? So it is better you have to mention alternate beneficiary, so that any beneficiary who dies during your lifetime, and if you have not revised your will, so that the alternate beneficiary is already mentioned in the will, so that becomes also already clarified in your will. We have seen some of the people are making alternate to alternate also. So they are taking all situation in their mind. Sometimes it happens that there could be an accident, husband, wife, both is gone, or whole family is gone. What do in that situation? Those things, thoughts also people have explained to us, and they have accordingly included things in their will. What happens if? Amar is asking whether the will overrides nomination. It's true. Nomination is just a trusteeship arrangement. In all the those people around, please note that all the law is very clear. All the Supreme Court judgments are very clear. Nominee is just a trustee. No, will is always powerful than the nomination. So please note there are few WhatsApp messages here and there about flat and all, which we don't deny. The nomination will get asset, but that asset only to keep as a custody as a trustee. They cannot use it, they cannot sell it, they are not owners. So please note, nominee will get as per the law, the bank account, the demat account, the flat, the insurance, but they cannot be an owner. They cannot be an owner. Okay. So we are just repeating coupon code again. The coupon code for 20% off is WILL 2020, WILL 2020. You can use it for 30 days time, and after 30 days we will be concluding the offer. Can executor be beneficiary? Yes. We recommend that one of the beneficiary you keep as the executor, who is well aware of the situation they can do. If you don't have good somebody who can do this correctly, you can appoint executor to one of the beneficiary, and that executor can appoint a professional to help them. So it is always recommended that please keep one of your family beneficiary as the executor, so that they are also owner and they do it in time. Sam has asked if executor dies or refuses to execute. So what happens if executor dies or they don't cooperate in distribution of will assets as per the will? So what happens? The beneficiaries has to do. They can, if there is no alternate executor, because in our will we always offer also alternate executor. So executor dies or don't act or he refuse, an alternate executor can come in place. So one of the solution is keep an alternate executor clause. In situation where nobody is there, executor dies or there is no executor to act, you have to go and approach court of law. They will appoint an administrator. So that is something can be executor, can be one of the beneficiary, joint beneficiary can go to request to the court of law that please appoint one of us as administrator. The court may accept it, or they may appoint their own administrator from their panel. So somebody has asked, Chavi has asked, so what is the benefit of a family trust? Yeah, the family trust is another arrangement where many of people have said that how can we make it very sure and secure that nobody can challenge, nobody can guarantee it, anybody can challenge, and however it has to be court to decide whether those challenge stand in the court of law or it can be overcome. So will is not a foolproof. Will is good. So far it is not challenged by somebody who is trying to delay the process. Trust, family trust is arrangement which is fully secure. However, in the trust, family trust, one has to transfer all the asset to the trust. So that is a situation where it happens normally with the people in the industries, which are people who have got so many businesses and good amount of wealth, where they try to secure that this big wealth should not be challenged and got delay. So they try to create a family trust and they try to shift all the assets to the family trust. And that trust has to be run in certain time frame, maybe 5 years, 10 years, 15 years. So the trust has trustees and objects as per your wish. It's your wealth, it's your family trust. You have to decide who will be trustee, who will be the beneficiary, what will be the objects of the trust, what is the timeline. So family trust is an arrangement where you can do all these things, and it is done for avoiding any big challenge in a big properties. So that is something you please note. It has its own time frame and formalities, and we will surely assist somebody if you want those help. So somebody has asked, Rushabh has asked, do we need a probate if there is a will? Please note that probate is something which is required after person is died. So the will, what they have left behind, if you go to a bank or a flat society and just say that please transfer as per the will detail, sometimes the value is too big. Say for example, your demat or bank account value is say 5 lakhs, 2 lakhs, 10 lakhs. As per the law, they cannot just act on your will. They have to ask a probate. So probate is nothing but a court of law gives their authenticity. Yes, this is the will, which is correct will. This was the last will of this person, and there is no challenge. So this is something, an order given by the court of law, which is called a probate. And probate is normally, we have seen, is asked in big value properties and assets, not all. But if it is asked, you have to comply it with it. You don't have any choice. So going through the probate formality is also tedious and costly, but at least the wishes of your will be fulfilled after their compliance. So probate is not to be the reason that I will don't want to make a will because there is also probate. No, because your wishes will be complied after a few more formality. That is why we are saying even probators ask for some of the time, please do your will. Bridges has asked how no, you can access our offline services. You are welcome to connect us with our chat, online chat, or send us an email or a message. Our team will connect with you and they will guide you for the whole offline facility. Like if you make an offline will, our team will send you a questionnaire where you can give those details. Our lawyer will sit and write your will draft. They'll send it to you via email. They can discuss over the call, and then after your final suggestion, a final will can be given to you via email or via courier. So that's an offline will. It could a joint will, it could be a probate service, it could be a registration of will. All these offline services we can offer when you connect us. So Dharmendra has asked a question whether a will, a full document will, has to be submitted to a bank or a society or a demat and all, or which is necessary. Unfortunately, yes, you have to submit a full will, which the authority who are transferring the asset can see it, and if they have questions, they can ask. If they are not very sure, they can ask the family member to give their undertaking or the waiver or a declaration. Because if they waive probate, they will ask all the formalities to be completed by you and your family, so that they are not in a difficult situation. Because if you come with the will and if they act upon, and there is a challenge coming up later on, even the flat or society or a bank or a demat people will be in problem. So they are doing their job. You have to please understand, as per the legal way, they will guide you, and you have to follow those positions. So, Mr. Iyer, Satyanarayan asked, how do we normally distribute the joint asset? So, it's all based on which are the assets it is mentioned in the joint name. Some of the banking law are having different rules for certain either or survivor and those type of concepts. So, it's a case-to-case basis. However, generally, a general law, the joint asset, whatever asset is owned by person who has died, those shares should be go as per their will. So if there is a joint bank account or a flat, one of the joint owner who has died, his part has to be distributed to the family as per the will. That's the normal general legality. However, it depends on case to case. For a certain demat account, for certain insurance policy, we'll have to look into it and then we can guide you. So, Mr. Prakash Joel has asked, what is the time limit for going for probate and court fees and all? So, I don't see any time limit is framed. It should be reasonable time. But if normally people approach the court maybe within 3 to 6 months, once they have completed their final rites and their religious ceremony, and then when they go to the authority for transfer, the authority like bank or a demat or your flat people, they will ask the probate. If the probate is asked, you will have to go to the court of law. It could be 3 months, 6 month time. However, there is no time limit fixed. Court fees has to be paid as soon as you apply for the probate. The court fees in Bombay, the maximum is 75,000. In other states, there are different court fees. But for Bombay, if you have any asset in your will which is valued more than 11 lakhs, the maximum cap where you have to pay 75,000 court fees. We understand that it's going to raise it to 3 lakh rupees. So that will be paid along with your probate application. And after you make court fees, then only the court will take the further course of action. It takes 6 months time sometimes. It could be more. So depending upon the situation and the court load, it is take time on that factor. So once the will is signed, how one is to store it? Neelam has asked this question. So please note that will document is a simple written document. You can store it with yourself in your drawer, in your locker. You can give a copy to your executor or your family if you wish, and you can be given it to any custodian. We as a service provider, we also offer a custodian services. We charge annually fees for that, and then we keep it with us. We give a certificate to you that so and so person has made a will. The will is with us. This and this beneficiary should contact us and take a will. So the will document is with us, and we will hand over to a person after the somebody claims from us. So will can be kept safely so that nobody destroy it, or there is no problem in tracing to your family. It can be given to your friend, your any of your close relative also. WillJini, we are based out of Mumbai, and the will services that we provide is applies to all religions. However, our online will, we want to just explain to you that Muslim religion follow people who are following Muslim religion, there is a Sharia law applicable to them, and there are restrictions on writing a will. So those people should avoid using the online will. They should approach us for guidance and our offline services, because they have restriction under Sharia law for which we can explain to them. So all the people in the Muslim religion should avoid writing this online will for the 100% of the property. Writing a separate property for separate wills for separate property, no. Will has to be one for all your assets. To avoid any difficulty, will has to be one document only. Yeah. So there are a few people who have joined across the country who are NRIs. Our services are for all Indians who are sitting in India and abroad. So for abroad people, NRIs, I will have a word of recommendation, because there is a tax implication to them. In India, please note, India has no tax on properties being given to you as a legal heir. So whenever somebody gives asset via will, the recipient will not get any tax on it. They don't have to pay tax. But some of the people who are staying in US, UK, Canada, developed countries like Singapore, where the government charge estate duty or succession law tax and all these things, where they have to pay tax. So what we are suggesting to all our people out of India, that please make two will. We call it the concurrent will. Globally, it is allowed legally. You can make two will. One for your local asset and one for the properties in India, so that the Indian property doesn't attract tax in those countries. You can make two will. One is for your resident country where you are living today, and one is for the Indian. You can make, sitting there in your country, make an online will. It is quite valid. You take any two witness of your friend, relative with a passport number, it is still valid. So there is a facility for you as an NRI. At a very low cost, you can save huge tax on your Indian assets. Mr. Anil has asked whether somebody has died in 94, whether it is a time bar. Mr. Anil, we would like to look at it as a case to case. This is a special mention on that there is no time bar, but we need to know what has happened to those assets, who has claimed and not claimed, and anybody has any counter or filed any case. So maybe you can connect to us. We can guide you on that. You can add NRI. Somebody has asked Mr. Prasad as whether we can add foreign asset to in a will. Yes, you can add. In India, you can add your foreign asset just for the clarity of your family, but don't add Indian asset in your foreign will. So otherwise, you will have a tax. In India, you can add your asset just for the clarity and information, so that your family can use your foreign will also and do the required formality and claim the asset. The discount coupon what we have given here today, those things are applied to all our services. We offer across a flat 20% off to online and offline both the services. However, it is for 30 days period, so you should note it down and claim within those time frames. Yeah, so any property which is joint, say husband and wife, Mr. Shankar Kumar has asked. So yeah, if you are having joint property, it is normally treated as 50-50 if you are not mentioned anywhere about the ownership rights and all. And then the 50% of your asset you have to mention in your will, and 50% of your wife, she has to make her will. So what we are saying, clarifying to all of you, that normally we do have asset mainly a earning member earned out of a thing, and also joint member like a spouse has been kept. But legally, our suggestion and recommendation, even your spouse, your wife, whoever the owning the asset, should make a will also, whether a single will or a joint will. Otherwise, there could be a dispute and claims with for the understanding of those joint assets. Because yeah, legally, the 50% ownership with the wife, she can claim, and there could be a issue. So any will which is signed by foreigners in foreign country, whether the witness can be Indian or foreign national, witness can be any foreign national also. However, you just have to mention a passport number and name, so that in case of any requirement of witness, even today Court of Law in India, they do a conference video calling, and they try to see those person via video conference. They take their confirmation, and they allow those type of things. Those foreign nationals did not have to travel to India. So those things are there already. So foreign national can be a witness. Housing society and bank, whether they insist a will, even there is a nomination, no. Housing society and a flat, they have to act. All the wherever there is a nomination is there, they have to act. They can't become a court of law and ask a will to know who are the actual legal heirs. Their role is over. Their role is to give it to nominee, and it's nominee's responsibility to hand over to the legal heirs as per the will. Yeah, some of the people who are holding a will, they can write to the society that we are the actual legal heir. Don't give it to nominee. Those things doesn't stand in housing society law. Nominee will be given an asset, and that asset nominee has to distribute. Society will not come in the dispute, because nomination is the facility being introduced by government. So all the family issues, the societies, the bank, the no, debate people, they don't have to be party to the court of law. All the cases. So they are just completely out once they hand over to nominee. Then it's nominee and the legal heirs has to take it to the legality. Okay. So people who are saying, if I somebody asset, Soli Mirza has asked if they redeem any mutual fund, or there is a change in the stock in the equity market, or there is a sell in the flat or what, we have to do an additional will. So what we are saying, that codicil can be made, which is of one pager, similar to will, for a major properties, because your mutual fund, your bank account, your demat account, your stocks, all are dynamic. It will change every day. No need to do, because your clauses are legally accepted in the court of law at the last day of the when the death has occurred. So whatever is position on that day, it can be taken, because you are not mentioning the actual position of your mutual fund. You are just saying what is my mutual account scheme, or my demat account, or my common ID, what you are giving in your wealth or portfolio. Those account detail you give, that's all. You don't have to give those detail of what you are disposing and all. So whatever is there, it will be on the date of that will be taken as your asset. So Mr. Sam Bhandar is asked, can the asset be distributed to beneficiaries without going to executor, bypassing the executor? It is not. It is not allowed. Executor is empowered to do all these things. If executor is not doing that role, or executor is not doing the role to take the probate from the court of law, if it is asked, the beneficiary should go and go before the court of law, and then they say that one of the beneficiary can act as an administrator, or court will appoint their own administrator, executor, and that has to know for distribution. Because the beneficiaries has more than one, they may fight in distributing for the value and for the process. So that things are a little bit difficult to practically allow, and also legally. We are happy that you all are participating well. And today, Sunday, we have taken time from you, and I think it's worth for all of us for this education. I think we have answered all the questions. We are open for your question in future. You can send us on our WhatsApp number, what we have given to you. You can send us on email. You can call us also. We will be happy to answer you and guide you for all these things. And my all the best wishes to be safe during this COVID-19 situation. My best wishes to all of you, your family, your neighbors, and all the Indians and people in the global environment, that let us be safe and come out of this COVID situation. Thank you for attending this seminar. Thank you so much.